Good morning.
Morning.
I come on behalf of GACDL to really speak to the appellate section of this. I'm the chair of our organization's amicus committee. I'm also the secretary of the appellate practice section of the State Bar, and I do not come on behalf of that section, although I will tell you there's been much discussion about this provision of the bill, and that in the bar, and particularly our section, may later have a position on this as official. But a couple of things to think about, particularly with respect to Section 5, which is lines 44 through 49. This provision of the bill would apply to any evidentiary ruling that excludes evidence. It could be a hearsay ruling. It could be anything that excludes evidence that the state seeks to admit. Right now, there is a procedure in place where either the prosecution or the defense can move for a certificate of immediate review. If the trial judge grants that certificate, the appellant would then petition for an interlocutory appeal to either the Court of Appeals or the Supreme Court, whichever the appropriate court would be. We have found that trial judges and both of the appellate courts do a fantastic job of using that process as a filter. And generally, trial judges will grant certificates of immediate review if the decision was close, if the judge thinks it would make a difference to the outcome of the case. And our appellate courts do a good job of filtering out the interlocutory applications that are most worthy. As this bill presently stands, all it takes is for the prosecutor to certify in the brief that it is not being taken for purposes of delay and that it is a material issue. The court, neither the trial court nor the appellate court have any say in whether or not that is the case or not. That's not to impugn the honesty of any lawyer, but I can tell you that when you are an advocate, whether you are an advocate for the state or you're an advocate for the defendant, in the heat of battle, often you lose some sense of objectivity. I mean, the system sort of encourages that to some extent. And some of the things that the advocates think are material or think would not be taken for purposes of delay, the court ought to have a say in that. To give you a basis of comparison, in domestic cases that go to the Supreme Court on discretionary application, under their pilot project, the Supreme Court takes non-frivolous appeals. And we have to certify that it's a non-frivolous appeal. But the Supreme Court has the ability to say, counsel, I disagree with you. I think this is a frivolous appeal, and we're not going to accept your discretionary application. That is an essential part of docket management for the appellate courts. I fear that this bill, as it currently stands, would flood the appellate courts with appeals from prosecutors who disagree with evidentiary rulings. And there is nothing in this bill that gives the court, either the trial court or the appellate court, the ability to say, I disagree with you. I do think this is not material, and I do think that this is probably just going to delay things. To think about it further at the policy level, our appellate courts are really set up to deal with post-conviction cases. By that point, the record has been assembled. The court can assess whether or not an error was harmful or harmless. And even with the cross appeal, I fear that lots of issues will come before the court before the record's had a chance to be developed, before the court can know the meaning or the significance of an issue that's before it. I think the other part is that an appeal takes a long time to complete its course. If the Court of Appeals or Supreme Court, and our Court of Appeals, I've heard, is one of the busiest intermediate appellate courts in the nation. If the Court of Appeals has to take a case simply because the prosecutor has said, has certified that it's not frivolous and it's not taken for purposes of delay, you will find that many cases will be delayed during the life of that appeal. And of course, Mr. Chairman, you spoke earlier about that's why we have judges. That's why we don't have computers or software hearing these matters. I think while these appeals are proceeding in an interlocutory basis, I think the party that's going to suffer the most would be an indigent person who cannot afford to make a bond, because as that case is delayed, that person may languish in a county jail behind the wire and in the hard bed, as you mentioned earlier in this hearing, and while in the county jail at the expense of the county taxpayers. Beyond that, the longer, particularly in the molestation context, we've spoken earlier about the trauma of a victim having to come and testify. Delaying the process while an interim evidentiary issue gets appealed for perhaps a year, while we wait for the transcript to be prepared and the record to be sent up, also is going to potentially worsen the trauma of the victim, who has to have that pending case going for longer than it already does. So I would ask the court to reconsider. I mean, I'm in the court. I say that all the time. I would ask the commission. I would ask this committee to reconsider. I don't usually come here.
Just got a chill on my spine. I'm not a good one.
Sorry about that.
That's all right.
So I would ask you to take a look at that. I think it could have some unintended consequences. The other thing I would like to talk about briefly is this element of knowingly. I think, Representative Hightower, I think your questions are very good. As I was reading that provision of the bill, I thought about the FedEx guy, or the UPS guy, or the mailman. A common way that drugs are trafficked is that people will sometimes actually mail drugs over UPS or FedEx or the Postal Service, and technically, with the word knowingly in the first instance, technically the FedEx delivery guy who unknowingly delivers drugs within a package would be guilty of trafficking under that statute as it currently reads.
Mr. Pack.
Thank you, Mr. Chairman. Quick question on the appellate rights, and I think I agree with you and Judge Lawton. What's your first name? I'm sorry, Judge Lawton. About that issue, is part of the issue related to when you file your motion to suppress over a motion to eliminate pre-trial, and the judge rules close to the trial, that causes the problem delay of the jury trial, right? Because as it's written right now, you have to bring it before jeopardy attaches, which before the jury's impaneled. Question: is part of the problem not getting, not filing and disposing of motions to suppress? Does that relate to the lack of discovery you get in time from the prosecutor?
Well, Representative Pack, currently the requirement is that certain motions, particularly motions to suppress, have to be filed within 10 days of arraignment. And sometimes that can be a problem if you don't have your discovery yet. I think on a similar note, one problem that I could foresee, I think if this bill were to pass as written, as I think defense attorneys would likely start moving some of their motions to be heard after the jury's impaneled or in a bench trial, because jeopardy is attached at that point. So I think tactically it might make a lot of sense for me to try to, or particularly a judge who doesn't want to be appealed under this new statute, to simply start hearing more evidentiary issues after the jury is impaneled, because then...
Well, if the judge doesn't want to be appealed, they just deny your motion then.
That's correct.
Then you will have no right to appeal. So I'm not quite sure if that will happen what you're describing. I do agree with you, you might have some time limits on when you want to file your motion. But I could foresee a situation when you're filing a motion to eliminate, because before trial you should know what evidence you want to keep out. Could the solution be that you put a time period when you have to file a motion and it has to be ruled on before the judge, before the case is set for trial?
I think the reality of the way dockets work, though, is that we have a hard deadline that we have to file defense motions, and oftentimes just by the sheer number of cases on the docket, those can't get heard until as you're on the eve of trial. And then my understanding of the deadline to file a notice of intent to introduce similar transactions is that's 10 days before the trial. So that sometimes that creates a problem. Sometimes the evidence doesn't, or the witnesses, or even the knowledge of the similar transactions doesn't arise until you get later in the case and both sides are beginning to prepare for trial.
Any further questions for Mr. Key? Seeing none, thank you for your testimony.